I have Joe Meyer here. He's going to be your presenter. I'm just going to read a little bit about his bio and background, and then I'm just going to let him take over and do a great presentation. All right. So Joe has over 18 years of experience working in the information technology arena. His experience expands across multiple industries, including retail, healthcare, finance slash banking, pharmaceutical, education, and government. Joe is a current and active member of the technology or the Technical Advisory Service for Attorneys, the TASA, and was a keynote speaker at the NYC Law Summit on healthcare law. In addition, Joe is a panelist for the HHS slash NIST Healthcare Summit and has invited to speak at several of the top cybersecurity and risk conferences in the nation over the past several years. Joe is currently the director at NCC Group. All right, now involving questions. At the bottom, you should see a section that says QA. You can click on that QA right there and ask any questions you want. And Joe will take some time out to answer those for you. But here's our presenter, Joe Meyer.
Thank you very much. Thank you everybody for joining. I know it's a little bit 4 o'clock on a Friday, so I'm probably standing between some of you and hopefully your happy hour evening at home, social distancing. So again, I thank you guys for joining me on this presentation. As stated, I have spoken at several of the conferences between ISSA and ISACA and some of the big events. And I will say out of all my conferences, this is the first one I've ever done remotely, specifically virtually. So I guess 'tis the new world. So nonetheless, I appreciate everybody's time and interest in this topic. I know it's something that seems to be a beating of a drum. It tend to have, be a little numb. It's been come January, so we're about a year and a half since CCPA has been birthed. So just kind of wanted to give you guys an update really on where this was. So when I first created this presentation, it really became more about like the buffet, the state privacy buffet. Specifically, CCPA kind of became, as we know, the GDPR of the United States, but really what were the other states doing? So obviously, just a quick recap, right? Who's affected, right, by CCPA and general privacy rules to begin with? Any business can be subject to the scope of the CCPA based on any of the types of data that they process from California residents, right? So here an example of how some of these come into play, right? So we have state level momentum. How did this come about? We wanted to pass the act in 2018. It became, officially official. It was unofficially official, then it became officially official, and it's undergone several reiterations by the state attorney general. So nonetheless, just a quick idea. Again, I know we have sat through most of these, but GDPR, people say, oh, GDPR is just CCPA is just a GDPR for the United States. And kind of, it's a good baseline. If you're GDPR compliant, you're obviously not CCPA, but we'll cover that as well. Being able to really learn how to respond and knowing how we are, what the ultimate intent of this regulation is, really kind of comes into play with what we need to know, right? So this is actually specifically taken from the law itself, right? The purpose and intent of the California constitutional right, which in my opinion, that's the state constitution. My opinion we'll talk about the constitutional right from a federal level. The constitutional right is the state constitution referred to in this statement. So these are pretty much the high level rights that and I keep using this, right? Because California is the one that has really defined, implemented, and is finally holding, well, let's say, holding organizations accountable. So these are all the information items that we have to hold each other accountable to. So specifically businesses, it does not include B2B, right? So a lot of the things that have come up in the last couple of weeks or last several months is business to business. There was an organization recently that the CEO sent a very political based email to its base, right? And the company is based in California, but it was a legitimate email. It looked like maybe it was hacked at first, but no, the organization agreed that it was a CEO's email. And the first thing people started to do was raise their hands and be like, this has got to be a CCPA violation. It's not in the sense of it because it's considered B2B, so therefore that's kind of what comes into play. So again, just like GDPR and just like privacy, it's specifically regarding you being protected and your information being sold for purposes of marketing, so on and so forth. So let's just let me dive into a little bit more specific information. Let me just pull up my last little sheet here. My apologies. So right now, since it's been birthed, right, California is starting to actually now conduct enforceable regulations, right? So we've learned a lot about it. So the same way GDPR was in Europe, we didn't know a lot, right? There is no certification. You can't say, oh, here's my certification to prove that I'm GDPR certified. Here's my certification to show I'm CCPA certified. A lot of that became because we were waiting for the courts to have case law. So I believe some of the big five targets rather regarding GDPR, specifically also CCPA, are currently undergoing trials and discussions at the corporate level, at the court level. And a lot of these outcomes will now start to dictate the change of what privacy looks like here in the US. There is no CCPA jail. We're still on the dock waiting for the wind to catch the sail, almost at the same spot we were when the bills were first introduced. Now, granted, we ourselves, we've had to untie ourselves from the docks, but we're still only about an arm's away from the dock. So the fact of the matter is we have not gained much momentum or even a push on what we know about CCPA, short of what's currently happening in the courts. We have been able to confirm and clarify that there's actually several key pillars of the act. Now, if you read the law, it's pretty case law, it's very law and regulation based, it's a little monotonous. But like GDPR, there's a big reliance on the case law we were talking about, because these will provide those valuable points that will kind of help us really kind of find the idiosyncrasies between what we need to do as not just clients, but really on behalf of clients, on behalf of ourselves, but for our clients or for our businesses or as their counsels. So under CCPA, it's very likely that a significant violation could be an extinction level event for companies and organizations. Probably not for the big ones. But when you think about GDPR penalties are based on the total global revenue, but only up to 4% of your company, right? A bigger company equals bigger fines. However, CCPA allows for the recovery of damages of up to $750 per consumer incident. And there's no cap on how high these fines can be. Now you can start to see how if we're not really positioning our organizations, our clients, our customers into a good spot to understand where the intricacies lie, it could really be an extinction level event for any company based on the size of the breach. So we've talked a little bit, right, about GDPR and CCPA about the same thing, and it is, but it's kind of different. The typical consulting aspect of it depends. It's the freedom of movement, just like GDPR, there are articles. Article 4 is the one in GDPR and CCPA. I believe it's Article 9 and 29, I believe, one of the higher 20s in GDPR, drawing a blank at the moment. Those are the ones that really kind of go into the specificities over what we're really looking for regarding personal data protections in the laws. So in California, they really wanted to increase the role of personal data in the contemporary business practices, because what's happening is we've all seen the breaches. We have small to mid-sized breaches, but yeah, they may not be at the multi-million, record level. But if they're at the several 100,000 record level, and then we multiply that, let's say by times 10 or 100 of these small to medium-sized businesses, now we're really starting to get to the crux of the information. So again, California has led the United States in passing laws aimed to protect this. I think, not getting into political or personal, but a big part of that is because a lot of the technology, Silicon Valley has a very strong presence in, it is in California, right? So a lot of those organizations are based in California. So by default, it also has the requirement or the desire to really kind of protect those people. Same way that New York City has the NYDFS, which is more of a breach notification and other things regarding financial districts. You can start to see how the economic makeup of those states and what type of businesses are in those states can really start to drive the regulatory aspects regarding protection of either personal information, collection, or just business impact related identities. So CCPA is also taking on one of the bigger debates that were actually brought forth by the GDPR implementation, which is kind of where I think a lot of this comes into play for it being, we have a lot to learn, right? So we always hear the term right to be forgotten. And this becomes a very, very unique, specific, and difficult thing for us to tell our clients and for us to work with our organizations with. Because now we're starting to get into a little bit gray area. And this is the gray area where case law and eventual case law will help us create more definition to. So the applicability and onus, so regarding the right to be forgotten, it's the applicability and onus of an action on a company with regard to, let's say, physical tape backups. So unlike using NAS, right, and network access storage or the cloud, we still have a lot of organizations that use tape backups. I mean, not too long ago, we were still doing Iron Mountain audits, right? 5, 6, 7 years ago. So you have a lot of organizations, and this is a great example of how these conversations come up to play. So you have an organization where somebody wants to be the right to be forgotten, but this organization, company A, let's say, has tape backups, physical DLT, digital linear tapes, originally called compact tapes. And for many lawful, legal, purposeful reasons, they have information backed up. They fit within their retention policies. They fit within all the reasons you would do backup. Some of these reasons are that, but the data sets are much larger than the data sets that they need to be retained. Let's say, some of these reasons are data sets. So your personal information is part of a data set. So it's a data set within a DLT tape. And let's say for SEC, the Security and Exchange Commission, they have to retain this much information legally for other reasons. You have a small little bit of data set, let's say in this overarching file. It becomes very hard for me to require or force an organization to prove that I have the right to be forgotten and remove me off that tape. So what we're going through now is, for tax purposes, ongoing litigation, investigative purposes, you're going to still be a part of it. However, as of the last right date of those data tapes, that's when they pull them back out. So let's say that they pull them back out for a purpose, whether it's litigation or something else. You now have the right to request that organization to remove any data about yourself under the CCPA statute. However, the technical architecture of the tape backup isn't similar, right? We talked about with a hard drive or the cloud. So under CCPA, organizations are required to identify the sets of incremental backups through which full backups contain consumer data. And only when those tapes are pulled for business use, like during a data restore or need to access other information on that tape, is the company then required to delete that data. It is not required for that organization to pull and load those tapes to then delete that small data set of the consumer during the right to be forgotten request. So I think that's kind of one of the differences. There's a similarity, but again, we're making some progress regarding CCPA and GDPR. Now, GDPR obviously has a much larger caseload, if you will, regarding the amount of people that they're covering. I mean, they're covering pretty much almost an entire continent. So now we kind of get into the nuts and bolts, right? So we got consumer rights versus business obligations. And this is kind of where we need to either know as consumers what our rights are, but also if we're working with or for our organizations, and we want to make sure that it is our responsibility to know as consumers, the left side, and it's our responsibilities as well, professionals, to know the right side. So collected data, shared data, right of action. I know we can all read restriction. Portability is going to be a big deal. That's what we're kind of referring to a little bit on regarding the tape backups. Now, if you think about it, a lot of these organizations also need to have this data to collect transactional and basic information, whether it's fraud processing, fiduciary duty is one of my favorite words to say. These are all these things that are required, but these are the obligations that we have on behalf of our businesses in order to be able to collect. Now, let's dive a little bit deeper into the consumer privacy, because it's important for us on behalf of our organizations or for our clients or whatever it might be, to actually understand what the intent is. And this is something that's not really clearly stated in the CCPA, something that's kind of explained in the GDPR, but not as specific. So what we get into is a little bit of all of this, right? So we get into the collected information. You have the right to know and ask an organization based in California or doing business with California residents to see if they have access, what kind of information they have on you, or how is it collected. But at the same time too, notice how it says information to a third party, right? You have the right to be forgotten, but this is kind of where you have the right to also make sure that they don't sell it. By you, I mean people who are California residents. But again, I say this because it has farther reaching implications. Right to access parental information that's shared with the party and right to deletion. So this is the GDPR version of right to be forgotten. Right to be, processing, again, and this doesn't also qualify into, so one of the things going on right now, shocking, right, is this gigantic election. There is a very unclear, fine gray line between political ad campaigns and CCPA. CCPA, that's going to probably be another case study. I've tried to spend the last couple of weeks trying to find the little intricacies between the three. I'm really struggling to find what side of the fence I sit on because I can kind of see both aspects. And there's no provision specifically for non-ad campaigns, but from a political standpoint. But I don't want to get sidetracked on that. So again, automated decision making, right? So you have to make sure that a business cannot make a decision about you based solely on some automated process based on your information without anybody's input. And of course, our right to action. Now, here's where we get into a little bit of the other aspects, right? So we have the, we have a strict opt-in. We have required businesses, clients, et cetera, for anybody dealing with California individuals or GDPR, similar aspects. This is where you'll start to see a lot of the same transparencies and similarities between GDPR and CCPA with a lot regarding what we can and cannot do. So an obligation is placed on a business to provide notice to consumers about certain data practices, privacy operations, et cetera. So this is pretty much our disclaimer, right? Our little banner at the end. GDPR specifically states that you can't have right to opt in automatically checked where we have to then uncheck it. CCPA specifically states it has to be unchecked with that option. So little differences here and there, but these are all requirements we need to do or we need to do on behalf of our clients to help prove or be CCPA compliant. Data breach notification, right? Because if you think about what we had talked earlier with regards to how much the fines can be, you really want to make sure that your data privacy or specifically your data breach is kind of on par with the honesty, because if you're off on what your expectation is, we go back to that discussion regarding a extinction level event. Just take a sip of water. So a mandated risk management. This is something that's been going on in the compliance and the privacy world for years, but nobody's really been able to mandate it. PCI has a risk management requirement. HIPAA doesn't really do a risk-based approach, specifically even regarding privacy. ISO requires it based on what 27001. APEC CBPR requires to do a formal risk assessment, but these are all formal mandates that have really kind of came up in the last 5 years. And the simple reason is you really need to know what the risk is. Because if you're going to continue to, the whole point of privacy, whether it's GDPR, CCPA, Colorado, New York, or Seattle, or whatever it might be, the idea is to make sure that we have an idea as to what our process is. And we'll kind of get into just to the easy high level of one of the easiest ways you guys can at least meet intent and remove a lot of negligence and let's say basic liability of let's say not knowing where to start. The risk management aspect is really, really a place. And it does say a formal risk management process. And this could be a risk assessment against NIST 853. It could be a NIST, a risk assessment against the CSC top 20 controls from SANS. It could even be the ISO risk baseline, or you could even go further deep and use the 9000 series or 3000 series from ISO and have a full-blown risk assessment. Either way, we need to make sure that we understand what data is coming in, where it's coming from, where it's being stored, how it's being processed, and how we're getting rid of it. And until we do those things, the risk assessment, we won't be able to know any of those things unless we do the risk assessment. All right. So again, we cannot discriminate against a customer. So let's say I want to, John Doe, Jane Doe, they come to me and say, Mr. Meyer, I would like your organization to, I want to exercise my right to be forgotten. Please show me all the things you have on me, where it is, and then get rid of it. And then prove to me that I'm forgotten. Great. So this is, I can't turn around and be like, oh, I don't ever want to serve that person goods again, or I want to make sure that the services I'm currently providing them now get degraded because now I'm upset because they did this, right? So that's another protection that we have to make sure that the business is covered, and we have processes and procedures in place to make sure that we are going above and beyond to make sure that this isn't happening, even at the store level, let alone at the corporate level. So the proposed limitation, this is one of those where they definitely stole it from GDPR, and I'm okay with it. Because at the end of the day, it prohibits the collection of our personal information except for a specific purpose. So instead of us just doing screen scrapes or doing data dumps of database files that were sitting off of an IVR, we need to make sure our organizations are only collecting the information for things, for services, for items, for widgets of which that purpose exists. That becomes very difficult to do if you're not doing your data mapping, if you're not doing your data discovery, and you're not doing your risk assessment. Again, process limitation, again, pretty GDPR specific. We can't collect it. We shouldn't be able to process it in any manner that's not accurate as well. The fiduciary duty, once again, I get to say it, obligation, right? We have to exercise the duties of care. We have to act in the best interest of the consumer. I'm not a lawyer, so I can't get into the specificities of what liability and negligence looks like. But as stated in the opening, I'm an expert witness when it comes to cybersecurity items. So, for example, organization or person A versus organization or person B, or in litigation, they bring in me as an honest third party and say, here's a situation from a cybersecurity, from a privacy, from a framework standpoint. What is the intent or the ask? I'd be hard pressed, I think, on this one to understand what the best interest of the customer is without taking in all the other aspects. Because I think as long as you're meeting the first 6 items on this, 7 items before the 8th number, you're doing that. So it's just something to kind of consider and know that as case law starts to come out, a lot of these gray areas and in between these, if you will start to get a little bit more clarified. So in a nutshell, when we're doing our data mappings and we're doing our data discoveries, here's what we're looking for. These are the information that this is what we're looking for. When we collect all of these items, regardless of the industry, regardless of the data, in a lot of organizations inside of a medium organization, I can tell you right off the bat, unfortunately, sales and marketing, by no real fault of their own, are probably the 2 worst offenders of privacy laws, whether it's GDPR or CCPA, because by nature, that really is their job, right? To collect items and start to incorporate and make potential trends for leads. So when we're doing all of our data mapping, we're looking at all of these. Yes, photographs or videos. This isn't a Polaroid. This isn't sending my 110 film in the 80s to get processed in a bag and waiting 4 days for it to come back and hoping I got 3 pictures correct out of it. All of these have geotags now. All of these have the type of camera it was shot on. When you go into the metadata of just simple videos and photos, you can see a lot of information. Genetic data, location data, right? We were just talking about the geotags. All of these informations are things that we really need to be aware of. Now we have, I can tell you, my organization, we're heavily vetted into transportation space. So maritime cybersecurity, autonomous vehicle cybersecurity, railway. We get into a lot of these aspects. And I can tell you, we collect so much. Thankfully, we do it on the back end, but the amount of information we can collect can easily be on the other end, let's say aftermarket. A lot of these items, so all the cameras that we have, the license plates, the black boxes that sit within certain electric vehicles, our creditworthiness, our mortgages, smart devices. So let's just assume all the IoT shenanigans that goes on here. But all that data that's collected on the back end to Google Nest, to Amazon, to wherever, whatever organization we're sending that information to really is kind of key. You can see how how ancillary and mundane this could be if you don't look at it, but how monotonous and tedious it can be when you start to get into it, depending on how much goes into it. Right, so we're talking, and we're just now scratching the surface, and I mean this isn't even all of it, but you could see how quickly our data mapping and our data discovery can really kind of fall off the rails really quick. So identifiers, real names, alias, postal addresses, unique identifiers, internet protocol addresses, like emails, account names, social securities. So HIPAA has, traditionally 18 identifiers. So if you have a HIPAA violation, it's because in one way, shape, or form you took, name isn't a HIPAA violation, but name in my diagnosis definitely is. But name and an address isn't a HIPAA violation, but maybe name, address, and prescription, or address and prescription, right? Because I can make an association between, okay, I can look up a regional association. I can look up that J. Doe lives on 123 Anywhere Street, and I know that this prescription specifically for COVID-19, so I can now assume that John Doe has COVID-19, and that becomes a HIPAA violation. So those are 18 potential options. Here we have 25. Now, each one of these is a violation and a potential fine in and of itself. It doesn't need to be compared to, biometric information doesn't have to be required to be personal information, but any one of these definitions are protected and therefore can become a potential fine or breach or an issue for our organizations, for our clients. All categories of information were enumerated in the Civil Code 1798.80, I believe. Why I remember that, because every time I think about it, I think about Revolutionary Wartime. But there's specific reference to the category of information that's been collected. So you can't just look at these and be like, oh, these are very specifically vague. There's kind of a method to the madness. So all categories of personal information that are relating to, let's say, characteristics of protected classifications under California or even federal law have specific reference to the category of the information that's being collected. So race, ethnicity, gender, etc. So the commercialization, the way we turn that information into to include records of property, products, etc., can really start to now cross those lines. Now you start to see kind of the correlation between this and, let's say, excuse me, the HIPAA reference I'd used earlier. So one of the other things kind of about this I think is interesting is, so far to date, one of the first case that actually alleges a violation of CCPA was actually filed on February 18th, 2020. It was against a security and smart home company, where the plaintiff, who actually brought them to court on behalf of a class action lawsuit, purchased the company's security device. He alleged that the company actually failed to implement adequate security and actually shared its consumers' personal information with unauthorized third parties without their consent. So they actually alleged that the company violated provisions under the CCPA that would actually require the businesses to provide a notice to the consumers of the right to opt out in the sale of their information. This lawsuit is the first to expressly state and cause. The lawsuit is the first to expressly state a cause of action under the CCPA. There are some, informational aspects that have been received for some clarity, for better definition on things. But one of the biggest questions we field around the introduction of CCPA was, what constitutes a consumer or a resident? I was a California resident, but I moved, so am I impacted by the law? Simply put, if you have a state issued ID that is active and says California, then you are most likely involved from a consumer standpoint. That comes into play because how do we also tell our customers and our clients and their businesses how big and how far reaching is this? So now we kind of get into like the privacy buffet, right? Where are we sitting? California is kind of the first one to really get this going. And we've heard lots of notions and lots of information regarding Nevada, Virginia, other states kind of trying to hop into the privacy bandwagon, if you will. So let me show you this little infographic here. They will produce the new version of this probably in December. They do it every 2 years. So by the end of this year, we'll have an updated version. So let's just look at the 4 years ago. Let's look at 2016. All the states that are in white, no laws, no privacy laws. Well, let me rephrase it. Data security laws, and it's important to say that. So you see Florida, Massachusetts, Rhode Island, Oregon, California at the time, both government and businesses. You fast forward 2 years, amount of white states went away, right? We have lots of blues, which means, you know, there's some sort of data security law coming into play. And I can guarantee you, when this new infographic comes out in a couple of months, there's going to be, I believe there's only going to be 4, 3 of them in the Midwest and 1 of them is in the Northeast, I believe. New England in particular. I think because I think Idaho even has one on their Senate or on their state floor at the moment. So we have an opportunity really here to know what's coming down the pipe. So in the wake of CCPA, sorry, clicked on the wrong side. So in the wake of CCPA, Nevada privacy law took effect in October 2019, and then states they've wasted no time in 2020 introducing new privacy laws of their own. So joining the chorus of Virginia and Florida this month, was it this month? I think last month, state lawmakers in New Hampshire, Washington State, Illinois actually released their respective takes on what residents really wanted their privacy rights to be, as well as even what the corresponding business obligations would be. Now, these aren't necessarily, they're not in play yet, but these are on the legislative floors, right? They're legislative drafts. So New Hampshire, this year, January 8, 2020, New Hampshire has a closely aligned deal with CCPA. They pretty much adapted CCPA's text almost wholesale in most instances, but not as new amendments. So that draft's bill is effective date is actually set for January 1st of this year, so 2021. Then the enforcement date will start 6 months after that. So I'm trying to say New Hampshire regional data. Oh, so data breach. So this is why I bring up data security laws, because a lot of these green a lot of these green states across the country, a lot of their data security laws are actually just data breach notification laws. So when you see a data privacy law for a state, look at it more closely. And moreover, you don't really have to get past the first couple paragraphs to see this is just a data breach notification law. So you don't have to worry about your organization working in some of these states, because at the end of the day, it's really just a breach notification law. January 23rd of 2020, Washington State pushed one, but they actually ended up closing it or having it strike down in lieu of a new one. So let's look. I know this is a kind of a hard one to see, but let's just kind of look at where we're at. So you can kind of see where, unfortunately on this slide, I apologize, the legend didn't come through, but the ones in the blues are the ones that have just been introduced, right? So if they have a strike through it, they've already been knocked down off their state legislative floor for either redo or review. Blue just means that somebody's introduced them to legislation and we're having a conversation, which I think we can all assume the government's a little bit slower than we would expect. So therefore, these will probably be on the floor for at least until early January, definitely after the election, and probably not until after the next swearing in is. The green means they've had a vote for approval. You can see there's only 2 states that have had that moving forward since CCPA and Maine and Nevada have pushed theirs in. And obviously red means they've been implemented. In the case of, let's say, Connecticut, North Dakota, and Texas, they made it all the way to, or they had something in place, but they've struck it down and removed it in lieu of, again, something else. So you can see on the right all the different items that kind of come into play. If you look under consumer rights and business obligations, these are those items that we saw on the states on the previous slide, where we're talking about what are our rights and what are the business obligations. So, and I'll just real quick, I'll go into New York. So, New York is in blue, but they have NYDFS. They have all these other items. Well, but remember, those are breach notifications and industry specific. So New York actually included a broad consumer right to opt out of any processing, but not the sale of personal information. Where Texas was a GDPR style, and now they took it off the floor because it had prohibited a business from collecting any information under very specific circumstances. So anyway, you can see that there's lots of people jockeying to get their own state privacy. The problem is what happens with all this? What happens if everybody gets their way? All right, we don't have a federal mandate. We never will have a federal mandate on privacy. We will never have GDPR because it is not in our Constitution. Now, the closest thing we've ever had, right? There is no constitutional right or guarantee of privacy for US citizens in the Constitution. There are four rights. There are four mentions of the word privacy in the Constitution. One is the right for privacy to not have to state you have a weapon, regarding the Second Amendment. Another one is the right to have privacy regarding your religious denomination. Another one is the right, I believe it's a right for garrisoning of troops or something. My point is there's only 3 to 4 references of privacy in the entire Constitution. None of them, rightfully so, have anything to do with data privacy, because why? It didn't exist back then. So we did reauthorize US the Freedom Act, and then it was reauthorized again in November of last year. It had expired, I think November 5th, so they reauthorized it. Why is that a big deal? Well, because we all know if you don't know, the USA Freedom Act pretty much allowed government agencies and other entities to pretty much be able to scoot around certain privacy laws to get what they need under the guise of, let's say, terrorism, governmental operations, etc. So when we leave it to the states, there's no federal oversight, which what happens, that creates the chaos, right? So let me just go back really quick about the federal. Let me go back before I don't. So regarding the Constitution, the Supreme Court has actually found that the Constitution implicitly grants a right to privacy against, there it is, governmental intrusion from the First Amendment, the Third Amendment, Fourth Amendment, and the Fifth Amendment for reasonable security procedures and practices. If you think about when that was written, security practices and procedures are not the way we think of them. Those are actual like militia, military, quality of life safety items. So the constitutional concept of privacy uses the theory of natural rights and is generally applied to which is now being applied to the new informational age and communication technologies. The problem with that is that there's still no mandate, right? So if you actually speak to a constitutional attorney or lawyer, they have a hard time making that leap or that connection. So now going back to the next slide, chaos, right? So given the lack of federal privacy standards similar to GDPR, PIPEDA up in Canada, or Chinese security law, Japanese Sansho-shan, which are also the 4 pillars, there's not a congruent baseline to base these user privacy laws off of. We would be using somebody else's, but we don't have a federal law. All those other ones, PIPEDA, CSL, Sansho-shan, CSL, they all have a federal, some sort of nationalistic mandate. So the problem we come into play is, who's a citizen of what state? When are they a citizen of that state? Where were they when they weren't a citizen, when they applied for the opt-in? All the metrics that a state would have, what are the metrics that a state would have to use to determine all that? Like, think of it from a personnel, from a client, or from a consumer standpoint. How would New Hampshire be able to enforce their privacy laws to, let's say, an Idaho company or an Iowa company enforcing, or an Iowa citizen enforcing to a Florida company? It becomes very difficult, right? So what's the metric we're going to use? Most of us don't even live where we were born, so you can't say, oh, well, you were born here. What if I was actually born in Puerto Rico? So does that mean I apply to all of them, or I apply to none of them? So an assumed approach is that it can all be used as a baseline to help build and maintain reasonable security procedures and practices. That's really kind of our biggest theme here. So when we get into privacy laws and international data exchange, without a basic set of commonly legislated answers to what rights a U.S. citizen is owed, let alone any implications that would add to a state data privacy requirement, we could disrupt trade. We could disrupt the ability to do business globally. One of the things we got into, there's the Asian Pacific Economic Countries, APEC, cross-border protection, has a certification, which is actually a privacy certification. It's a low cost, it's pretty much a decent risk assessment. You can actually get certified against GDPR and CCPA, and in some cases, Vietnamese even security law. So there are options out there, but if we start to create all these idiosyncrasies between the states, we could really mess up some foreign trading and other global aspects. Last but not least, right? Of course, Ironically, state governments hold a vast amount of data about their citizens, including PII, social security numbers, driver's license, tax and financial information. And yet all states have security measures in place to protect data in the systems. However, 29 states require by statute that the state government agencies have security measures in place to ensure the security of the data that they hold. They've only been enacted within the last 2 or 3 years as cybersecurity has come up and about. I know for a fact, Florida has a privacy law. The irony is the Department of Motor Vehicles for the state of Florida was caught by selling the DMV information to third parties of their drivers. So you can see when we leave it to the states, we have an issue. We have a big problem when it comes to continuity, right? Not just across our country, but ideally globally. Sorry, I messed up a few of my animations. So we're getting towards the end, guys. I promise there's not too many slides left, just a handful left. So again, when it was first established in the European Union, it really was a potpourri. It was pretty much, let's throw it all on the wall, see what sticks, and let that be our baseline. The problem is we, as the United States, haven't gotten past that stage. So California said, we'll just go ahead up and we'll do it. Remember, the problem is we're still just basing on the efficiency of law. We don't have a right to privacy. We don't. Constitutionally speaking, US citizens do not have a right to data privacy. We have too much of it. There's too much of our organization. And obviously, right, we've all heard the statement, if it's free, you're the product. And that comes into play because that's really how a lot of this is based on. So when we ever want to be key in the data, we have a couple items that are out there, right? We have HIPAA and the privacy aspect. We have COPA for the Child Online Protection Act, FACTA. But at the end of the day, we don't really have anything that protects us or that we're required to be. So that's why the introduction of CCPA really has an interesting ploy on it, but I don't see how we can adopt it. If we're not going to do it at a federal level, I don't see how we can still leave it to the states. So when it comes to our organization and our discussions, how do we keep our clients? And how do we keep our organization safe? Where do we go from here, right? Short of case law, it's real simple. Let's just be smart. So we talked about the data. We talked about our, so here's you guys have been patient. You've been great so far. Here's kind of the easiest tricks for us to get to where we need to be, either as a consumer, for our clients, or for our organizations. This is the easy approach, right? We really just need to know where our stuff is, right? Right here, the additional of the organization has the onus of responsibility to prove that you know where your stuff is, you know how you're processing it, and you know what you're doing with it. Data privacy awareness workshop, period. You just stand up and you get in front of the the board, you get in front of the stakeholders, you say, cool, what is it that we do here? Why is it we're doing it, and what are we collecting? Most of us know how that's probably going to go. So we're going to have another one of those conversations. We're going to have workshops with the sales, with the marketing, depending on the groups, and say, this is what we're trying to accomplish. And then from there, we start the data discovery and mapping. Okay, I know that we sell this widget. In order for us to sell or send this widget, we have to collect all this information. That's PCI information. Cool. What do we do with that information? Nothing. Oh, wait, there's this one thing though where marketing takes it, and marketing likes to send them specific coupon books based on the fact that they bought 4 pieces of landscaping equipment. So we'll send them, landscaping or backyard coupons. Well, okay, that's a problem. What do you do with that? Oh, we put this in this other database that's not part of that PCI scope. Okay, what else is in that database? Well, we sell this Fitbit, and we collect all this Fitbit information. So you can see how it really can skyrocket and spiral out of control. So privacy risk screenings are really the way. This is a conversation you have to have with yourself. Once you've identified data discovery and mapping, you have to have that honest conversation with the stakeholders, with the business owners. Why do we need this? Why? Why are we collecting this? Is this just a skin tag on something else we're collecting that we need? Because we're introducing risks that we don't need. Have that honest conversation. Have an actual risk screening of all the bits of information on those previous slides, of all those 25 or so identifiers, and really see, do you really need this information to maintain your business, quality, etc. And then after you've had that conversation, hopefully think of it like a Russian egg. Hopefully, as you've gotten down to the smaller eggs, you can say, okay, we have to collect this. We know that these fit 20 of the 25 identifiers. Let's do an impact assessment. What happens if somebody calls us and wants to have a right to be forgotten? How hard is it for us to do that? Is this the only places where this information sits? Do we even need this information, or if we can't even extrapolate it just because it's part of this dump that we're getting from outside or outside information B? Assign a risk to it, because that now we're starting to get into that risk management and that risk assessment we were talking about earlier. Because if you go back up to the top of the slide, right, you have the onus, businesses have the onus of responsibility to prove that we know where our stuff is, we know what we have, what we're doing with it, and where we're putting it. So if you have gotten to the fourth stage right now, then you should have that conversation and know where it's being held. Now you also have to do a health check. So now you've done all this stuff, great. Now let's look at all the systems and all the processes and all the things that we're doing on the back end to make sure that, think of this like your PCI audit. Think of this like your high trust audit. Think of this like your FFIEC audit, your SAS 70 assessment. These are the things. Now we're looking at the operational and the technical controls that are protecting those data sets. And that's the health check that has to happen at least once a year by GDPR standards and even by CCPA standards. There should be an executive summary, because the executive summary is going to still go back to the top. That's going to be the narrative that shows your knowledge and your responsibility. Have a dashboard that says, we had that slide earlier. You can guys go on there. I think it's IAPP. I'll look it up during the question and answer for a moment, or you guys can reach out and get a hold of me. But you can find those slides or that infographic anywhere. Have a delta. Have a cross matrix between, I know my organization's in California, or we deal with a lot, we're in New York, but we deal with a lot of California people. Oh, and Nevada. Oh, and some Rhode Island and some Florida. Learn who you and what you have to apply to, and then just create that matrix, because that would be where your executive summary and report comes into play. Not to mention, have an external counsel come in, have an external company come in and do an actual detailed findings or recommendation, because chances are you may not know how ugly your baby really is. It takes paying somebody a little bit harder to have that honest conversation with you, because those are where you have those extinction level events. If you can't be that honest with yourself, or if you can't get your organizations to be that honest with you, then that's when you end up being the first case study, if you will, in California law. All of these things really have to go to the approach. So what do we do? When you're having this we're on the second to last slide. So thanks again for everybody hanging in there. I appreciate it. This is just a high level approach. When you have these interviews, when you're doing your data mapping, when you're having your privacy risk screening, when you're just having the general conversation with the stakeholders, these are the questions, the types of people you want to meet. Whoever the role is, I mean, the roles can change, the titles, whatever. When this is just the high level people you want to start with, because guess what? The physical security guy probably doesn't know what you're doing with the widget information, but I bet you he could probably tell you what he's doing with like vendor information. The sysadmin probably can tell you how many databases have weird information with SKUs on it and customer database. You kind of see the point here. So what you want to do is have a high level overview, right? These are some of the high level things. If your organization doesn't even know what these are, there's absolutely no way you know where your information is stored. There's definitely no way you're going to pass general assessment, let alone prove the onus of knowledge of where your stuff is. Because these are the items that are really going to help you create quite a baseline. I mean, it's more than just the infrastructure of the house. We're talking like probably drywall and some windows as well with these. So take a screenshot if you wanted to, if you're interested on these, but these are kind of the basic overview list. This right here, this approach really will get you to at least the high level start, and you'll start to realize the amount of rabbit holes, the amount of mining holes, and just a general unraveling of the sweater that can occur just by doing those two things. Last but not least, why I left this here, you must have a corporate risk register. We go back to the last slide, right? We talk about creating all those associations of stake. How do you know how can you do a privacy impact assessment? How can you even play in a privacy space and worry about things like cybersecurity and onus of responsibility if your corporate risk register isn't even involved? And it could be as simple as the output of your risk assessment that you did against NIST, against CSC, against ISO, whatever it is. that risk register is a start. If you don't know how to do a risk register, there's some great opportunities online that just kind of give you a high level overview. But chances are there's somebody in your organization who, if you're a medium to large size information or organization, you probably have two people. One who knows everything about them, and he's probably wrong, and the other one who probably has a good idea, and that person is probably more correct. So with that said, I just wanted to quickly thank everybody. I know it's time for Q&A. I also understand that it's, again, it is close to end of week. It's been a long week for a lot of us. So I appreciate everybody's attempt, and I appreciate everybody's attendance. And hopefully you got to learn something. Hopefully I didn't talk your ear off too much. That's it. I appreciate any Q&A.
All right, that was a great presentation by Joe, and I really appreciate that. It looks like we only have one question in the Q&A. Can you see that pop up there, or do you want me to read it to you?
Okay. Question, how do you think the right to be forgotten will affect higher education? Is it possible? It is possible with such decentralized environments. How much information is public records? That's a great question, because now we're starting to get into things like FERPA, right? We started to get into your higher education compliance aspects, which now we're talking about federal mandates. So the way, let's say we take FERPA. Let's just we use FERPA for student PII, because that's federal, and let's say CCPA, federal will always trump state laws. So even if I wanted to have even if I wanted to be a right to be forgotten, and let's say I'm from LA, I go to UCLA, and I want the school to right to be forgotten me, they can't, because under FERPA, the federal law requires them to hold on to it for the FERPA requirement, which I believe is 3 to 4 years afterwards. So that's kind of where it comes into play. Now, if there is a federal law that plays into that with higher ed and the right to be forgotten, that kind of goes into why I don't think we'll ever see a federal mandate. But I think the answer is, unfortunately, I don't think it will affect higher ed specifically because of the FERPA mandate. Next question is, would you be able to touch on the importance of downstream supplier management regarding privacy law and compliance? This is this is kind of like the meaning of life question. We've had this conversation, and normally this conversation ends up having to lead to several bottles of scotch afterwards. It's a great question, John. So this is kind of where I think a couple things come into play. We're going to have, I think case law will obviously have a downplay on this, but I think, again, if you're looking at downstream supplier management, vendor management, procurement, any of those items, if we can have, specifically for anybody new, let's just take away the current downstream, which is a big risk we'll get to in a second. But during procurement, we can handle a lot of this by putting in the right contractual languages, making sure we state what we can and cannot receive, making sure that even during the onboarding process, we are clear and they are clear as to what they need from us, what they will send us, etc. That kind of feeds into the knowledgeable, the negligence aspect, right, regarding proving your knowledge. But when it comes to things like current mandates or the current supply chain, current vendors, but depending on what industry you're in or what industry you're dealing with, there should be a general just best practice security health check regarding vendor contracts. I know PCI says you have to have it every year. I think SEC requires you to do it every 3 years at least. Anyway, there should just be good general hygiene from a security standpoint to go through and look at the contracts, look at the service agreements, and make sure that that information is in there. Chances are it's probably not. So we would have to have an amendment. And even if you don't want to change the contractual aspect of things because of, let's say, M&A, SLAs, general contract shenanigans that takes forever, just make sure that when we do the risk register or when you're doing your privacy impact assessment, you can say, we send this information to vendor X, customer D for these purposes. We never receive it back. And if we do, we receive it back for this purposes. And then when we receive it back, we store it and stuff like that. So again, that data, the data mapping as to any of the information that you send downstream people really needs to be clearly described and vetted by you, because once it's out of your hands, there's really nothing you could do with it. Unfortunately, we also have seen many legal situations where you are guilty by association. Even if legally you're not, the reputation can be such, like, nobody remembers the HVAC guy who got Target hacked, right? But we all remember Target. So by proxy of making sure we have those cases. Now, if you think about what we said last on the last slide too, which I'll go back to, let me just go back. We go down to the data inventory and you know the example of shared contracts for third parties. We go back to all the other items. I think one more. Let me go back one last slide just to help reiterate my point.
You're going to give you a 5-minute warning here.
Yes, sir.
Yep.
So we go into the compliance index, right? So we get into the privacy risk screening. All of these items right here on this slide, if we can cover that for our vendors, assume that our vendors are not protecting anything, is really the best answer I probably could have given you. So I'm sorry for the long-winded answer, but if we do the things that are bulleted here and we assume that our vendors are not taking care of us, and then that'll allow us to create those invitations to be better. I hope that answered your question. I appreciate the interactivity. By all means, again, my name's Joe Meyer. I am on LinkedIn for NCC Group. I think it's literally linkedin.com/Joe Meyer. So feel free to reach out to me if you guys have any questions. I appreciate everybody's time, and I appreciate the opportunity to present and be a panelist here for this great conference.
Yes, sir. And we appreciate you coming through and speaking to our attendees here. Attendees, if you want, you can go on our Triangle InfoSeCon 2020 website, go to our exhibit hall, and there will be a bunch of information in there for you to consume. And I do see some people in there giving him some thanks and some claps for the presentation. It was absolutely amazing. And we do, one more time, appreciate you coming through and speaking to our attendees. I'm going to end our presentation here due to a time gap that is very minimal. But
Yes, sir.
other than that, thank you for coming out. And attendees, continue to enjoy the rest of your 2020 InfoSeCon. Thank you.
Stay safe, everyone. Thank you.